my niggas turn shooters. All my ops turn rats. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the Ooda. Welcome to the Ooda. All my niggas from the Ooda. All my niggas turn shooters. All my ops turn rats. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck. All my niggas from the Ooda. All my niggas turn shooters. All my ops turn rats. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me.
Listen, we are back, man. Listen, today is Diddy's appeal live in the Second Circuit Court of Appeals. Catnot Williams got the live audio, man. It's crazy, man. I was about to run down to the courts, but Catnot Williams got the live audio. So I do want to play some of this right now. Salute to her, salute to anybody. Let's just take a chime in to see what the hell's going on and what's any updates that's happening right now live. Make sure y'all dropping likes. Salute to everybody. Let's get right to it.
I will. Why don't we lead? One of your arguments is that it would violate the Sixth Amendment to consider acquitted conduct. Let's put it that way. And I guess I would ask you, is that not a question that is foreclosed, putting aside whether, in your view, Watts does foreclose this on a part of the Supreme Court? It has certainly been a holding of this court that sentencing courts may consider acquitted conduct at sentencing. Isn't that right? Panels of this court have held that.
Yes, Your Honor.
So then my question is, other than preserving your argument for consideration by this court en banc or by the Supreme Court, how is it that this panel could, in your view, overrule precedents of other panels of this court?
So let me say first, and I'll get this, where I was going was towards the guideline.
Sure, but let's just start with the Sixth Amendment first.
I think the court doesn't necessarily need to resolve the constitutional
No, I understand.
question.
Assume though, because you did brief the Sixth Amendment issue, what it is that you would expect this panel could do in light of prior precedents of this court saying that it is constitutional for a sentencing judge to consider acquitted conduct.
Two things, Your Honor. First, as we've argued in the briefs, we believe the Apprendi line of cases, including the more recent ones, and I would highlight in particular, this wasn't discussed expressly in our briefs, but was alluded to in the amicus briefs, the Erlinger case from 2024.
You're saying that those cases implicitly have overruled our circuit's precedents?
No, I'm simply saying that those cases further point in the direction of holding that it would be unconstitutional.
And I guess I understand that, but we typically cannot, as a panel, overrule a prior precedent of this court, full stop, unless there has been an intervening decision of the Supreme Court or of this en banc court categorically doing so. We can't find that our precedents have been undermined by subsequent developments and abandon them. That's why we have the en banc process.
I understand, Your Honor, and if this court is not inclined to take up that issue for those reasons.
Well, it's not a question of inclination. I'm asking you why we would not be bound by prior precedent, regardless of the validity of your arguments, which maybe are good ones to take to an en banc court or to the Supreme Court. I'm just talking about stare decisis here.
Well, I don't think the court has expressly addressed this issue since the guideline amendment. I understand that the guideline amendment is a separate issue, but the reason the commission amended the guideline was in light of these constitutional concerns expressed by, among others, Supreme Court justices. But I also think there's another.
I guess I'm lost there. You're saying that there have been, I mean, if we have a binding decision of the Supreme Court in Watts, we have binding decisions of panels of this court. You're saying that we can look at dissents of the Supreme Court, which are not binding, or we can look at statements concurring or dissenting in the denial of cert as overruling binding precedent? You're not suggesting that, right?
Your Honor, again, I don't.
No, I just want to, are you suggesting that?
We're preserving the argument.
That I get.
Okay. I really don't want to spend a lot of time on that, if I may.
Well, we're going to be here for a while, so don't worry about time.
Okay, good. Thank you very much. So there is a second piece of it, though, that is relevant to that question, which is that in the I believe that precedents of this court in the 3553 analysis, including Vaughn and Johnson, have held that, notwithstanding the rule that Your Honor referred to, that district courts must specifically explain in their arriving at their sentence, they must specifically consider the acquitted conduct and, the jury's acquittal when assessing the weight and quality of the evidence that the district court is relying on, and that did not happen here. So I think that's important too. Now, if I may, I'd like to go to
that line of argument I'm familiar with. And I'm going to apologize. I'm not familiar. Where did you raise that issue with the district court below, that even if it is constitutional to consider acquitted conduct, he should consider the weight and quality of the evidence below?
Well, first of all,
that's the Cordoba Gigante line of cases.
It's we cited the Vaughn case in our papers. And
before the district court.
Before the district court, and I believe it was in our reply brief. But I would also just point out that throughout our papers below, we made abundantly clear in over 100 pages of briefing that for multiple reasons, the district court shouldn't consider acquitted conduct. But
no, that's a distinct, there are various arguments one can make against acquitted conduct. One could make a Sixth Amendment argument. One could make a guidelines argument. One could also make the Gigante line of argument saying it is permissible, and yet you are not, as a district judge, compelled to take into account acquitted conduct because you must also consider the nature and quality. And arguably, I suppose, under some lines of cases, one would ask the district court to adopt a higher standard of proof when doing so.
That's not what I'm really saying. When I'm talking about what Vaughn says about what Vaughn says specifically. I'm not suggesting that.
But Vaughn just says that the court should consider the acquittal when assessing the weight and quality of the evidence.
Correct.
That's it. It's one sentence in Vaughn. And then it goes, as Judge Nardini referred to, into citing Cordoba and Gigante. But how did Judge Subramanian not do that here?
Didn't do it at all. If you read his statement of reasons, he simply says, I'm only sentencing you for the conduct you were convicted of, and then he goes on to discuss all of the acquitted conduct.
But at the sentencing hearing, he acknowledges that the acquittals, and he says, he acknowledges you were acquitted of these charges. Are you arguing that under Vaughn there needs to be a detailed explication as to each fact, how the acquittal on the other charges goes to the quote weight and quality of that evidence as to each piece of conduct considered? Or is it enough for the district judge to acknowledge, I get it, you were acquitted on these charges?
No, it's not enough. Obviously the judge acknowledged that he had been acquitted, but that's not enough. That's just make weight. And I think in both Vaughn and in Johnson.
Make weight?
In other words, he said, yeah, there was an acquittal, but he didn't explain.
You mean he didn't mean it, or he wasn't thinking it? What does make weight mean? It's a rather disparaging characterization. And I want to understand what you mean by it.
Well, what I mean, that's not what I mean, just to be clear. My point is simply that what Vaughn requires and Johnson requires is not just an acknowledgement that there has been acquittal, but some sort of discussion of why the judge, notwithstanding the acquittal, finds that the weight and quality of the evidence supports enhancing the sentence. If I may, I'd like to go on. McClinton made clear the Supreme Court would take up the issue of the constitutionality of acquitted conduct sentencing if the commission didn't act, and the commission did act and amended the guideline to ensure that not guilty really means not guilty. And this case is exactly what the guideline was written to address. Mr. Combs was acquitted on sex trafficking and conspiracy, but convicted on prostitution charges that didn't require proof of coercion or conspirators.
Well, we're going to get to coercion and all that, but let me pause on a couple of these guideline questions and ask you why we would even need at least some of them to get into this debate about the scope of acquitted conduct. Let's start with the leadership enhancement. My understanding is that under the leadership enhancement, as the guidelines provide, it can be imposed if there are at least 5 criminally responsible participants. Is that correct?
Correct.
So you have Mr. Combs, who was convicted, correct?
Correct.
So he's one. You have the 2 escorts who traveled across state lines. I understand that you are trying to challenge the convictions on the theory that they were not actually planning to engage in this specified forbidden activity, but assume that they were, and that we were to upheld those convictions. Those 2 would be criminally responsible participants, correct?
Well, the district judge relied on Christina Coram and Mr. Combs's employees and certain employees.
Yeah, but if there were 5, we have enough. Didn't he also rely on the 2 escorts?
I don't think so.
Okay, well, let me ask this. Here's my question. Would the 2 escorts be criminally responsible participants if they traveled across state lines with intention to engage in the forbidden activity?
Well, this court has to review the findings below.
No, let's stick with my question. You can go back to it. Would the 2 escorts be criminally responsible participants under the guidelines if they cross interstate lines with intent to commit the specified activity? What is forbidden by the Mann Act?
Don't think that's clear at all under the Supreme Court precedents about the Mann Act. The people transported are often not viewed as co-conspirators. There's an old case, I'm forgetting the name.
No, the question isn't co-conspirators, whether they're criminally responsible.
Well, it's this, I mean,
Not the same.
The Supreme Court cases, and I apologize that I can't remember the name of it, would only consider someone to be criminally responsible if they were involved in arranging the transport or something like that, but not necessarily the person who
Right, I recall
traveled.
those cases.
So
Okay,
so
that would be your argument as to why the 2 escorts are out, or an argument why the 2 escorts are out. And what about the 2 named victims in this case, who pretty sure the district court cited evidence that they had participated in the arrangement of transportation?
The government never took the position that they were co-conspirators.
I'm not talking about co-conspirators. I'm talking about whether they're criminally responsible under the guidelines.
Well, it's the same, for all practical purposes, the same thing.
Really?
Yes. Yes, I think it is, clearly.
If I cause someone to commit a crime, the person who commits the crime is guilty as a principal, and the person who caused the person to commit the crime is guilty as a principal. But that is a conceptually different concept from conspiracy, correct?
Yes.
Section 2 conspiracy, Section 2, 18 U.S.C. Section 2 is not the same as Section 371.
Right.
Okay.
If I may, Your Honor, the district court didn't rely on those others. This court has to review the district court's specific findings. The conspiracy that Mr. Combs was acquitted of clearly required the jury to find it that he acted with other people. The government argued that he led the conspiracy to the jury, and the jury was also told that if they found any 2 racketeering acts, even of the same type, and that he participated with someone else, that was sufficient, and yet the jury acquitted. So
Limit. That would be sufficient to find RICO? If you find that 2 people agree,
it wasn't a RICO charge, it was a RICO conspiracy charge.
But it's not, you're not guilty of RICO conspiracy if 2 people agree to commit a predicate,
That's
right?
not what I said.
Right. And that's not what the district court instructed the jury,
No,
right?
the instructions, the only disputed elements were whether there was an agreement with at least one other co-conspirator, whether Mr. Combs knowingly joined the agreement.
Agreement to blank. Agreement to what?
Agreement to participate in the conduct of a racketeering enterprise.
Right. So one could agree to participate in a predicate act without agreeing to participate in the affairs of a racketeering enterprise, right?
The jury also necessarily, on the facts of this case and the way it was argued to the jury, there's no way that the jury wouldn't have concluded that there was a racketeering enterprise if they concluded that Mr. Combs committed these crimes.
Now you seem to be
with
going
others.
into Sixth Amendment collateral estoppel areas though, right?
No, I think what the court has to
Cole.
look at is what is what the jury necessarily determined in determining what the acquitted conduct
That's a collateral estoppel argument under Cole. I mean, there is this thing that we say acquittals don't constitute factual findings of anything, right? They are determinations that somewhere within the elements of an offense, the jury found something not proven beyond a reasonable doubt, but they didn't make an affirmative finding that anything else.
No.
Now, we do find sometimes in Cole, for example, that for collateral estoppel purposes under double jeopardy, the jury must have concluded something or another. And that seems like where you're going here.
Well, Your Honor, the commission wrote this guideline for a reason, right? And it requires courts to figure out what the acquitted conduct is. And the simplest and clearest way to do that is to look at what elements the government was required to prove for the counts of acquittal and the counts of conviction. And so if the jury, in this case, what we have, let's take the sex trafficking counts. The only disputed issue was whether there was coercion or threats or fraud. And that was one element. The government's case focused on that issue, its arguments focused on that issue, its evidence focused on that issue, and the jury clearly rejected that argument. So we know.
So doesn't the coercion as to the two pieces of evidence that the government relied upon for at sentencing, right, which is the threat to one threat to Ventura, one threat to Jane. I think one was to release the tape. The other was we're going to I'm not going to pay your rent. Doesn't that establish the intent of the Mann Act? That is the intent to violate the Mann Act. That's what the district judge used this evidence for. He says that it overlaps to this extent. That is, the RICO conspiracy overlaps with the Mann Act, and insofar as we're talking about intent here. And why don't those two pieces of evidence support his factual finding and that there's intent for purposes of the Mann Act?
No, Your Honor, for two reasons. First of all, the intent element and the coercion elements are, as the government said, totally separate. And under our view of the acquitted conduct guideline, you have to look at it by element. And this type of analysis shows why the relevance test is problematic. But I want to also.
I understand your point about the relevancy test, but isn't that just nomenclature? We look at substance, not at labels.
I don't think it's nomenclature, because this is a relevant conduct guideline. The whole point of the guideline is to take acquitted conduct out of relevant conduct. And a relevance test really is another way of saying, well, acquitted conduct is not relevant unless it's relevant, which makes no sense. But I do want to talk about the specific incidents and why that's not correct.
Okay.
So first of all, with respect to the Cannes incident, there's actually no evidence that there even was a Mann Act offense in connection with the Cannes trip. So the government's argument is that threats were supposedly made on an airplane flight returning from Cannes to New York. Under Broxmire, United States against Broxmire, 616 F3rd 120 at 127, a 2010 case from this court. The court held that for purposes of the Mann Act, the intent to engage in prostitution, which has to be a dominant purpose of the travel, has to coincide in time. And there's no evidence that even on the airplane, they were planning a so-called freak-off. And moreover, there was no evidence in the record that there was a freak-off other than Ms. Ventura's testimony.
Wait a minute. Pause. You just said there was no evidence other than a witness's testimony, which is another way of saying there was trial evidence.
Right.
The jury is the finder of fact.
So this,
But
not
they
only
rejected
was
her as a
this
victim.
argued to the jury in the summation, but the jury.
Salute everybody. This shit crazy. This shit crazy. So right now they're talking about the situation where Cassie was on a plane and Diddy was threatening her because he was saying that he had films of her and was saying like he was gonna release the films into the public, like the actual tapes and all type of things that he was using to coerce her into doing freak offs. So that's what they're talking about here. This appeal is not looking good. It's looking shaky so far. Let's get back to it though. Salute to my girl, Cat Not Williams, for the public.
Sent back a note asking for, quote, Cassandra Ventura testimony regarding Ken and the events immediately following. That's at trial transcript page 8085, which is at docket 632 in the district court. And we know that the jury rejected the notion that that there was coercion in connection with that incident. With respect to the Mann Act,
now you're mixing two things. Let's grant you the notion that they decided coercion had not been proven beyond a reasonable doubt. But I thought you were just arguing a different thing, that the defendant did not have an intent for purposes of the Mann Act transportation, during the conflict? Because then you were saying there was no evidence that a freak-off even happened. Now, we're sort of venturing down beyond whether the jury found coercion to now say, yes, because you could say the jury found, yes, these events happened, but they weren't coerced. That's fine. But now you're saying they also found that none of this even happened. And I don't see how that follows.
That's not what I said.
Well, you said there was no evidence that the freak-off happened except for Ventura's testimony, and then you were trying to argue the jury necessarily rejected Ventura's testimony. And I guess you're saying because they rejected the argument of the government that it was her testimony showed there was coercion, they must have rejected every single thing that Ventura said.
That's not what I said.
Well, that was the implication, so let's back up.
That's not what I meant to imply. The point is that the government relied for its the Mann Act. The whole Mann Act charges were basically an afterthought at this trial. They took up almost no time. The government relied principally on these two charts. And if you look at Government Exhibit 1402.
I understand that, and you made that point very well in your brief. So isn't your argument really that what the government...
They giving them pushback, bruh. Ain't trying to let off no appeal, boy. Every time she trying to twist they turn, bruh. Crazy. They is on bodies right now, bruh.
Government is doing here is mixing and matching. They're taking evidence from the claims that were acquitted to try to support the Mann Act sentencing for purposes of the Mann Act, but none of that jury was presented.
This is what they're trying to do, y'all. This is what they're trying to do, okay? Remember, Diddy had the RICO, Diddy had the 2X trafficking charges, but remember, he only got convicted of the tuition. So that means he wasn't coercing nobody, and all the other things that they was trying to get him caught up on, he beat those things. So that's why they was trying to use that in his sentencing as well to say, come on, man, how you going to charge him, sentence him so harshly when he beat a lot of these charges? But we understand that a lot of things within your trial can be used against you because it's still part of your case. So let's get back to it.
To the jury for purposes of the Mann Act.
Yes, Your Honor.
Is that a summation of what we're...
That's fair. And I think our view of the sentencing guideline as we briefed is that the way it should be interpreted, and I think this is very simple and straightforward, is that acquitted conduct can only be used when it is also convicted conduct. And if I may,
that's not gonna fly. That's not gonna fly, yo. Acquitted conduct, listen, can be used against you. Even though you're acquitted of certain things, they could bring it back. Let me show you what I mean. You see with Diddy, in Diddy's case, it was a lot of violence, abuses, and all of that stuff. So when it came to his sentencing, they was talking about all that. What about when he was putting hands and feet? What about this? Remember, he got acquitted of all that stuff. He never got charged for that, but don't matter. They bring in all of that. It's relevant to the case right now of why we should sentence him the way we're going to sentence him. See what I'm saying? So they're trying to act like just because he was acquitted of it, nah, it's not going to fly, bro. It's not going to fly. I'm telling you right now, it's not going to fly. You better try another tactic. That's not.
I can point to some hypothetical examples.
Before we do that, let me just focus on the Mann Act for 1 second, and I hope it will inform this discussion. So the Mann Act is indicted to say that the transport was of either, as to count 3, Ventura or the escorts, and as to count 5, Jane Doe or the escorts. But at trial, the government's theory was that count 3 is violated and count 5 is violated by transportation of escorts to engage with Ventura and Doe, right? So it's not Ventura and Doe that are transported for those convictions, isn't that right? Or because that's what the government's closing argument is talking about, transporting the escorts.
Yeah,
well, mostly. So is it your
escorts was transporting? And really, let me tell you, how they caught Diddy up on them 2 charges, they don't even need witness testimony to lock him up for the 2 prostitution charges he got. You know that, right? All they need is flight records and receipts, and then you're guilty, bro. Pop, and you're done. So that's how they got his ass with that.
Do you believe that either the transportation of Ventura or Doe or the transport of the escorts could be the basis of the jury's conviction on 3 and 5?
I think it was that if you look at the charts, the focus is on the escorts for sure.
Well, I was looking at the closing arguments.
Yeah.
The government's closing argument.
That's right.
So if the theory advanced at trial is that the escorts are the ones being transported, but we're referring to count 3 as the Ventura count and count 5 as the Jane Doe count because that's the person who was involved when the escort arrived, then how do we now, in light of that, how would we consider things like the con trip?
Well, then I would say then it doesn't count. But I think what I was getting at, and I don't think I was very clear, so if I may, I'd like to explain it a little better.
I'm trying to remember the con trip, yo. Was that the time when Cassie was beat up and then she had the black eye and she was wearing glasses and all of that? I think that was con they went, right? I think that was the trip when she was beat up and she was like on the red carpet with the glasses on and she had the bruises and all that the whole time. So we seen pictures of Cassie. Nobody knew she was black and blued up. Crazy. The con trip, they were in con and then they flew back to the United States. They were flying home. So the purpose of the trip, even if a freak off did happen, wasn't to engage in prostitution. It was to come home. And under Miller and Broxmire and the jury instructions in this case, the dominant purpose of the trip has to be to engage in prostitution.
So can I?
It's not gonna fly. Right before my homeboy speak, because he on her ass, bruh. Everything Diddy did was a FO, homie. What are you talking about? Everything Diddy did was a FO. He wasn't making no moves if it wasn't an FO. One time Cassie hit him and said, Sean, I'm horny, Sean. The nigga Sean hit back and said, you horny? Who you gonna call? Who you gonna call? Cassie flips out on him and say, yo, bro, what you mean who I'm gonna call? I want you, fool. So if it ain't an FO, he wasn't even having SEX with you. You had to bring somebody else in for him to even scrape it. Straight, he wasn't even scraping it. That's crazy, bro. I'm like, that's weird. How you not gonna scrape your own girl by yourself, bro? You need somebody to beat your own girlfriend, bro? I'm talking about actually, not no violence. To make love to your girl, you need somebody else there at all times. That's why they say the women wanted to sometimes do this because after they did the FO, they had alone time with him by themselves. So both of the women both said that, bro. So I'm trying to show you. So he kind of like using to be with him. You know what I mean? You gotta do an FO, bro. If you don't do an FO, he's not spending no time. He's a big businessman. He's a billionaire, bro. He's running companies all day. He do free calls from Friday to Sunday. The longest one went from Friday to Monday, 4 days. See what I'm saying? He's a businessman. He's running businesses all weekdays. Free calls is from Friday to Sunday. The longest one, I think it was on a New Year's Day, was Friday to Monday, bro. Every weekend. Every one. Once Cassie confirmed one, her first one when she was 22 years old, she did one every goddamn weekend, bro. For like 10 years, however long, bro. It's crazy, son. Insanity.
Ask you though, I hadn't understood the government's argument to be that the purpose of flying home from Cannes was to engage in the activity. I thought it was the fact that he went, according to the one witness, on the plane, sat next to her, showed her the video, and then immediately turned around and arranged for the escort to travel to the hotel where then the activity happened, was evidence that the thing that happened at the hotel is in fact what he intended to happen, as opposed to his argument that no, I wanted people to travel so that I could have an attractive scene, but if there was actual, sexual activity that followed, that was just something that happened. But by showing a video of people engaged in such activity in close proximity to the event that actually transpired with the activity, it showed that his purpose in making this whole arrangement was to have the activity occur, and that manifested his intent.
But that's not sufficient to establish.
That makes sense to me, bro. I ain't got no horse in the race. That makes sense, bro. He showed the videos on the plane, bro. It wasn't for no nice shit, bro. It's like some threatening type bot. That's how they were saying in court. Like he's trying to coerce her into doing this shit. You know what I'm saying? And it seemed like that when you was in the courtroom. It seemed that way. So it's gonna be hard. I don't think that this person. I don't know who's speaking right now. I wonder which one of Diddy's lawyers is talking. I can't even know. But I'm just saying. I don't really think they're doing a real good job. They're leaning too much on the acquitted charges. And they just need to make a better case, bro.
The Mann Act violation, the purpose of the travel has
Well, it's not
to be
sufficient, but it certainly contributes to it because you have to have intent, right? So I could arrange for the intent of anyone to cross state lines, and then various activities could happen. But it's not a Mann Act violation unless I transport them with the intent that those events transpire, right?
Right, that's my point.
So that's what I'm saying is why does this not go to prove his intent?
Everybody slap that like button, share, do whatever y'all want to do, but slap that like button. You know, Uda ain't a beggar. I don't run around begging you for your money. Know it. Never been that. With the can in my hand. Never been. I've been a Uda, never been a beggar. Make sure y'all slapping that like button, though. Thank you very much.
Which is an element of a Mann Act violation, that the reason he had the people, the escorts, travel across state lines was so the activity would happen.
I think that gets back to the point I was making earlier, that under our view of the acquitted conduct guideline, that is just too far afield, and it's basically like a relevance test. You're
Well,
saying
how do you
it
prove his
tends to
intent
prove
then?
that.
So what evidence, are you saying that some evidence of his intent does count as an offense conduct and some does not?
Well, first of all, if you actually look at her testimony, I don't think she testifies to what Your Honor just articulated. And in fact, the testimony establishes that they got to New York and then they had dinner and then he suggested a freak off after that.
Well, right. This is a question for the jury to infer about whether the temporal proximity between him showing a video to her on the plane and then immediately getting back to New York and suggesting it and having it play out is why he wanted the escort to be traveling.
But there's no basis from which to conclude that the jury even found that this particular incident
Don't let Giggs lie to you, bro. I was in England them times too. Don't let Giggs lie, bro. He was at Diddy crib at he threw parties at the mansion. Giggs from UK. Chill. I lived in London, so you know the vibes. Stop. Giggs is fronting, man. He needed Diddy. Diddy's shouted his ass out. Diddy let him use his crib to shoot the videos and all that. You know that, right? Facts.
Constituted a Mann Act.
Was this incident cited in connection with the Mann Act charge? Did the government ever point to this and say this is a Mann Act violation?
No. The Mann Act, the government's discussion of the Mann Act in its closing argument was focused on this charge.
So let me, we have to write an opinion here, and let's just step out of the weeds, and we have to enunciate a principle, right? And the guidelines, the discussion of the guidelines talks about line drawing exercises that courts have to engage in to determine where there's overlap, where acquitted and convicted conduct overlap. Can you articulate a principle that for us to apply, if you were writing the opinion, what principle would you enunciate that is, readily administrable by courts to engage in this line drawing exercise? Can you give me a bright line test of some sort?
Yeah, let me try. If I may, I'll try to illustrate it with some hypotheticals. So I think the test should be, and what the commission intended the test to be, that courts cannot use acquitted conduct for guidelines purposes unless the defendant was also convicted of that conduct. And in order to determine what that means, you would look at whether the same element that has to be proven in connection with acquitted conduct has to be proven in connection with elements convicted conduct. So for example, let's suppose you have a case in which a defendant is charged with drug conspiracy to distribute narcotics, as well as several substantive counts of distribution. And the defendant is convicted of the conspiracy.
My guy Shadow the Titan was, man. You know what I mean? Sending a little 10-10 for the shooters. You know what I mean? I need ammunition, homie. I was running out of bullets, bro. Had a couple of ops the other day. You know what I'm saying? You know how I go. He was PDFing. Had to waste a couple of ammunitions on them. But yo, salute for the 10. Or they need to replenish the snitions because I'm on PDF patrols. Don't get caught up. Facts.
And with respect to the substantive counts, is acquitted of some and convicted on others. When determining the drug amount, the court could not count the ones the defendant was, the weight from the ones the defendant was acquitted of for the substantive counts, but could count the ones the defendant was convicted of, as well as any other drug deals that were either proven at trial or are proven at sentencing if they're not charged in separate substantive counts. That's one example. Another one would be you could have a fraud case in which the defendant is charged in securities fraud as well as wire fraud, and it's the same exact scheme to defraud, the same false representations in both counts, but the defendant is acquitted of one and convicted on the other. The way to make sense of that is to say it's clear the defendant has been convicted of the scheme to defraud, and so you could count the entire loss amount, even though he was, let's say, acquitted of wire fraud, either because maybe the wire.
Okay, let's read this statement, y'all. This is a statement, okay? All of y'all do hideous things. Stop picking which sins you're going to highlight. The man was railroaded, period. And most of you have left home, crossed seas, oceans, and the lake for sex. I crossed some seas and some lakes and all of that. So, okay, I like traveling, so don't mind me. But I can't do that. Diddy's a grown-ass man, bruh. I don't need nobody caping for him. His mom's, my grandmother, she loved me to death. I tell her that's the real deal, though. Stop playing with me, bro. Go back in the trial, son. Diddy moms love me. But come on, bro. Let's keep it real. Diddy did too much, though. Was it like a railroad? Could have been like, yeah. The way they ran down on his house, they didn't run down on Epstein crib. Did you know that when they ran down on Epstein crib, they left the people who was watching Epstein's house with all of those videotapes and all that and entrusted them to bring it to the precinct for them? Or wherever their station was, or wherever their department was, the federal place or whatever. Did you know that? They never did that with Diddy. They locked up every damn body as soon as they ran to the houses, right? So I get some of that. And maybe some of this Diddy stuff was meant to take us away from the Epstein files. Trust me. I was thinking that while I was at the trial because it was just a fucking circus, bro. I'm like, what the fuck, bro? I'm telling you, bro. I was thinking about the Epstein files the whole time while I was at that trial for 40 days. Feel me? So I get that. But Diddy was a grown-ass man. And there's no right that why you abusing people like this, bro? The women wanted to do the sex. They wanted to FO. Cassie wanted to FO for him. She wanted alone time. Jane wanted to FO with him. She wanted alone time, bro. Why do you got to be beating people down, though? That's not fun. You taking the whole fun out of shit, bro. We ain't come to get beat down, bro. We came to freak off, right? So that shit ain't cool. That's why they asked Cassie in there, what would prompt you to leave a freak off? She said, when he would change, his eyes would change. The man didn't look like the man that I loved. That's what Cassie said. Her own words, bro. So some shit you doing is just too much, bro. You can still do your sexual lifestyle or whatever you're doing, but live your life, bro. But you ain't got to be beating on people and doing all this other shit, man, threatening people live. Went to go kill Kid Cudi because he was clapping, and her mom's Regina Ventura, who I saw and I had to protect at the court. Regina Ventura asked if I ain't hold her down. Who does the shooter? Regina Ventura, who I had to bark on people for at the court. Stop playing with me. She said, listen, man, bring Scott Muscudi. That's Kid Cudi. Bring Scott. They stayed at her crib for like a Thanksgiving, like a whole weekend, a week or some shit like that in Connecticut, bro. Stop, bro. I could tell y'all this whole shit. I was there, though. Trust me. Nah, nigga. Diddy's a grown-ass man. You got billions of dollars. You a black man. You made it from all the lowest places that we came from. Why are you up there doing the dumb shit? Why are you dumb? Why are you playing the dumb games? It's like R. Kelly. Nigga, you got caught up with Aaliyah from before, nigga. You still running around with these two floozies, these two chicks, Azriel, Clary, and them? You ain't separate yourself from these people. You ain't learn your lesson, nigga? Get your ass in the jail then. Stop playing, bro. You gotta stop playing with people, bro. Stop playing. You wasting your time and your money on this dumb shit. FOing all day. Like, come the fuck on, bro. Stop, bro. Be real, man.
The jury didn't find the wire.
That same motherfucker won't say that if that nigga was FOing your sister, nigga, or your aunt, nigga, or your daughter, nigga, you wouldn't be saying this nigga railroaded. You would be looking for the railroad to clap this fool. So don't tell me no dumb shit in my chat, bro. Tell me no dumb shit in my chat, bro. If that was your daughter, I want to hear you say it. You're going to shut the fuck up. That's what you would do if it was your daughter, though. See what I'm saying? Watch your mouth, bro. Right.
In furtherance or something like that, but it's clear that they did find the scheme to defraud proven because the same conduct underlies the element in both charges.
To what extent does does your theory rely upon the what the government argues in terms of the evidence? In other words, the case that's presented to the jury in terms of the elements.
It was part distraction.
Is that dependent upon that?
It was part distraction, but that nigga was wilding, son. This nigga filled up a fucking pool in the middle of a hotel with oil and Astro Glide slip and slides, nigga. What? What you got to do with your time, bruh? You filling up, the nigga destroyed hotel rooms across the world, bruh. It was like buying new apartments, bro, for him to fix the rooms, bro. Do you understand that? It was oil every goddamn where, on the doorknobs, on everything. They started putting linens down, sheets on the fucking furniture, sheets on everything, on the doorknobs, nigga, so it wouldn't be no oil getting everywhere. Do you understand this shit, bro? Do you understand this shit, bro? They showing pictures in the court of Cassie in the middle of a FO, homie, with linens everywhere. Linens on the floor. They got sheets on the floor, sheets in between the nightstand and all of that. What are you talking about? Cassie said she had to block the pee with her hand like this. It was getting in her mouth and choking her. What is you talking about? Man, y'all go to sleep, bro. Y'all go to sleep, bro. That was some wild shit, bro. That's wild, son. Linens everywhere on the floor. They peeing on her. Diddy and the nigga standing on the bed pissing on her ass like this simultaneously at the same damn time, homie. You ain't know what's going on in this case? Oh, all right, cool. I'll let you fucking know what's going on in this case, nigga. Trust me. That's crazy, bro. Him and Diddy pissing in her mouth at the same damn time, nigga. She said she had to block the pee like this, nigga. I said, what the fuck? Couldn't believe it, bro. That shit was crazy.
Or does that matter? Is that irrelevant?
I think it depends on the case. I think you have to look at the indictment and what's the charge and what's the government's theory of the case. So,
well, the theory of the case as presented to the jury, right? It's not their theory of the case in the abstract, what may be in the indictment, but it's what is actually. I mean, they have a case to prove, right? So wouldn't it be the evidence and the arguments that the government makes to the jury?
It's definitely very important, and I think that's why. That's why we think that the test that's used for collateral estoppel is. And
was any of the evidence and the arguments the government made here in connection with the RICO and the sex trafficking offenses, was any of that evidence presented to the jury?
Listen to me. Trump could run down on Iran. He cannot run down Iran on Diddy for them oils. Ain't nobody getting between Diddy and them oils. You better go run down on Iran for the oil. You got a better chance, homie, using missiles. You not taking them oils from Diddy. Okay? They said they have to have like 15 bottles of oil. Bruh. They said the oil was more important than the SEX, homie. This is what Cassie in the court saying, bro. I heard her. I watched her. I sat in the court with her there. Saw Cassie right here, her brown dress, all that, looking pretty and all that. So like this, man. He said the oils was more important than the actual SEX, homie. Okay? And the oils that Diddy was getting, oh, bruh, you never seen these oils. Bruh, this nigga had the motherfucking Sam's Club shits. Nigga had the big Johnson's & Johnson's oils, homie. You got to go to Johnson's & Johnson factory to get them oils. Huh? That's how important them oils was, bruh. Chill, son. They had to oil up every 5 minutes, bro. Diddy said, you're not shiny enough. You got to get glistening. You got to get shiny. You're just dry. You're too dry right now. That's what Diddy said, bro. You're too dry. That's what Cassie said he said, son. Fuck what Diddy said. That's what Cassie said the nigga said, son. Crazy, bro. I ain't got no horse in the race, bro, but I just can't say. You know what I mean? The fuck? I'd rather be even Steven, bro. Some people be leaning too much to a certain side. Like, come on, bro. It's crazy.
For purposes of persuading them to convict on the Mann Act.
Yes. I'm sorry. Were you asking just about the RICO or the?
No, both.
Yes.
So to what extent did the government's case at trial on RICO and sex trafficking overlap with the government's evidence and arguments on the Mann Act?
So, as the government said, itself said it was totally separate, but with, from the sex trafficking counts, the overlap, well, let me just back up. I'm
Should
not
a
sure.
district judge hold the government to that for sentencing purposes? And should the district court say, well, you put on all this evidence that the jury rejected, right? And now you want me to look at this evidence to support a conviction under this other, to support a penalty under this other offense that you were convicted of. But you didn't present any of that evidence to the jury.
I think you have to just start with what are the elements that the government had to prove.
Yes.
And
They went prostitution.
if they didn't have to prove, for the Mann Act, if they didn't have to prove coercion, they didn't have to prove a co-conspirator, then we know that there is no convicted conduct that includes coercion or co-conspirators. And that's really the starting point. And I think the evidence and the arguments just reaffirms in this case that that the evidence that the judge was relying on is totally separate and in fact was acquitted conduct because
Well, he's mixing and matching is what he's doing, right? I mean, the district court here reached into the evidence that was used to support the government's RICO and sex trafficking case to for purposes of establishing the penalty under the Mann Act.
Correct. And he found coercion when the jury had not found coercion, including as to those two specific instances, because the government made those arguments and expressly told the jury, which correctly under the jury instructions, that if they found coercion, each of those instances would have been sufficient to convict on the substantive sex trafficking.
Were there limiting instructions given or requested during trial that certain evidence would only be admissible with?
They're just trying to use the acquitted conduct to get this appeal. All right. I don't know if this is enough for them to do this. Okay. Yes, the judge, they was even saying they wanted to get at the judge, Submarinian, because he overcharged, they over-sentenced him based on the acquitted conduct. You know what I'm saying? But from the judge's point of view, parole wanted more time than that. Now it was parole, probation, that people. They wanted some more time, period. The government wanted more time, period. So the judge kind of fell in between a rock and a hard place and gave him like 4 years. You know what I'm saying? He gave him like 4. Because he'd been in there for like a year, so he basically gave him like 3. You know what I'm saying? He'd been in there for like a year and change, so he basically gave him like 3 years. But if he wanted to, first of all, if you've been to jail or you know anybody, bro, what the probation office is saying, what the parole people, what these people are saying, bro, that's the floor. That's where you're supposed to start at. You know what I'm saying? That's where they want for you. You know what I'm saying? Probation officers, these people have a lot of power. You don't understand, bro. What they say means something. So the judge actually took all of that into consideration and gave him like 4 years, but because his daughters was there, I could bring it all up. I could show you. I could read it to you, bro. His daughters was there crying. They were talking about love, the little daughter. I was in his court, bro. She was crazy, bro. A pastor went up and said, listen, I want you to left Sean into our hands, man. We're going to take care of Sean, and we're going to make sure he stay on the up and the straight and narrows. It's like, how the hell you gonna make sure Sean stay on the straight and narrows unless you ban all the baby oils? You know, he like chill, nigga. In the Astroglide slip and slides. Like, what the fuck? You can't do that, bro. But the pastor went up there and said, yo, listen, give us Sean. We gonna make sure this brother stay on a church guy. Make sure he stay on the right path. Stop, sir. 4 years and relax.
Respect to certain of the charged offenses?
No, and that wouldn't really have worked here because there was a RICO charge, and as I'm sure Your Honor knows, under RICO, basically everything
would have come in as to RICO, but the idea that it's admissible as to RICO, but not admissible, say, as to the Mann Act.
But
I guess what I'm going to
that
is
would not have been legally permissible in this case because the Mann Act was also predicate acts to the RICO. I mean, that just wouldn't have been a valid instruction.
Well, I guess where I'm going with this is, does that mean that all the evidence that was admitted would have been legally admissible to prove any of the particular offenses? So, going towards Judge Baker's hypothetical, is there a scenario here where the judge was pulling evidence that was not, I don't know what you would say, admitted for purposes of proving the Mann Act, and then it's impermissible, say, for the judge to look at it with respect to the Mann Act when he's at the sentencing period? And I guess what I'm asking is that in fact the case here, or was all of the evidence admitted for unlimited purposes such that there is no, as long as it would be relevant and probative to prove up another count, then it would have been permissible for the judge to consider it with respect to that count?
Well, I think the reason it's not permissible for him to consider it is because it's acquitted conduct. And the judge.
Well, right, but I guess let's give you that. Let's accept that. Let's accept that premise for the purposes of my question, that yes, it would underlie some of the acquitted counts. I think then the question becomes, is it overlapping, right? So would it be permissible nonetheless to consider it with respect to the convicted counts?
No.
And right, and I understand your answer is no, and I'm trying to get at why. So is it because it wouldn't have been admissible to prove the Mann Act count? In other words, does your argument depend on that at all? Or I think what I hear you arguing is if there is an element of the acquitted charges that does not match an element of the convicted charges, what is embodied in the element of the acquitted conduct, which here is coercion, fraud, is now completely off the table for sentencing. Is that your argument?
So that is our principal argument.
Okay.
There's a secondary argument, and I hesitate to even raise it, but it's, we've made it, that even if you actually adopt the relevance test that the district court imposed, that these things wouldn't have been relevant. But I don't think the court should.
The relevancy
go
test,
there.
I find your argument confusing on that because I think
it's
the
not a
district
real
court
argument.
made, I think,
That's just a
frankly, I think
fallback.
your brief mischaracterizes, sort of caricatures the district court's use of the word relevancy. I don't think he's saying relevant in the sense of relevant conduct under the guidelines. I think he's taking relate to in context of having probative value with respect to one of the elements of the convicted offense, which is another way of saying it would have been admissible evidence to prove an element of the charged offense.
I think that's right. And our point in the briefing below on that, especially, and I think we make this point in the opening brief as well, is that test is far too broad.
But it's not coextensive with relevant conduct. Because I think in your brief, you say that blows up the amendment.
Shadow said 1B 1.3 would allow it if he wasn't acquitted. Yeah, I can see what you're saying there, Shadow. Because the craziest thing that other people that got charged with the same charges that Diddy got, they received like probation. They received like a year in jail or some dumb shit. You know what I'm saying? So that's why they was trying to push for Diddy to get that. But Diddy's case, in one of those cases, it was a group of guys called Stebic, Tills, and another guy. But in his case, one person only made one trip across state lines. Stebic or what Tills or whatever the fuck, he made like 6 trips across state lines. So he got the most time. He got like the year. Other people who kind of engaged in it, one guy never engaged in no actual, but he did make one trip with a woman across state lines. He got probation. You know what I'm saying? So in Diddy's case, everybody was coming for him. So he was the one that was footing the bill for all this shit, of course. But what they was getting him with was a lot of that violence that he was on, bro. Because that's what the trial was about, bro. This trial was like a big RICO case that was kind of tried like a drug RICO. You know what I'm saying? Because it wasn't like a RICO that we would thought we was going to see. You know what I mean? It was kind of tried like they'd be trying like a drug type RICO conspiracy. And really the abuse, the domestic violences was the most serious things that they kept beating down the jury's fucking head. And telling me about the urine again. Tell us about the urine. What do you say about the urine? Yo, son, they wanted like 58 minutes about the urine. I was like, yo, this shit crazy.
Oh, no, you can't. That is some bullshit right there.
So the judge did bring all of that in. He said you was violent. You did so many things. And this was a lot of the things that the judge was saying when he was sentencing him. Trust me. He was like, yo, bro, you did a lot, bro. You really, really did a lot. Even though you were acquitted of certain charges or certain things, bro, that doesn't, you know what I mean? Come on, think about it, man. Cassie's mom was supposedly extorted, bro. She had to fucking take out a thing on her house so that she could get the money, and then allegedly Diddy didn't want the money, or he returned the money, or whatever the hell he did. But I'm just trying to show you, bro. It was so much going on here, bro. You know what I'm saying? Abuses out the woo-ha. You know what I'm saying? One day, Cassie went to Prince's crib, for a show. Prince was having like a party and doing a performance at his crib, son. She's like, oh shit, her and her homegirls went. She said they was in there chilling, nigga. All she seen, because you know it's probably like big land, backyard. I could just see the house, the doors of the windows of the back of the house open so you could walk to the lawn, whatever. Nigga, Diddy walked through the building like this, nigga. She said she seen him like this, doing a hammerhead shark. Son, she said she went like this. She dropped to a tuck and a roll. SWAT team to the grass, nigga. SWAT teams to the lawn, bruh. Happy feet. Happy feet is when you happily running. Happy feet to the V, bruh. Hey, you talk about some next time when Diddy bust that ass, bro. Yo, son. Yo, bro, the abuse was crazy, son. Yo, the wild one was this one. Yo, why, her and Diddy is they at like Philippe Chow's or some shit, like Roof Chris or like a restaurant type shit. You know what I'm saying? And she's sitting down chilling at the table, Diddy chilling with his peoples and all kind of people in the spot. You know what I'm saying? So Diddy must have been talking to a woman. You know what I'm saying? So she seen it. But she didn't say nothing. She was just, she seen Diddy flirting with the chick. And so she said, she did one of these numbers, right? It wasn't nothing. She said it wasn't much. Listen to me. They was going to the car. They went to a Cadillac Escalade. They had Cadillac Escalades with the motherfucking, with the bucket seats. Okay? Cool. He said, Diddy went in the car first. Soon as she got in the car, this nigga started to wow her up, bro. Beating her. She like, what the fuck happened? Yo, all because of that. Just because she went like this. And one of his guards said, she saw you talking to Shorty. And she went like this. You hear me? That didn't warrant this beatdown that she got. Yo, son, he was beating her, kicking her ass up in the fucking truck. She had to crawl under the back seats of the truck to protect her face from being stomped on, because that was one of Diddy's go-to moves, is stomping on your goddamn head, dragging you by your goddamn hair, and that was two of his go-to moves, bro. Stomping on your face, bro. She said she had to crawl up under the back seats of the fucking Cadillac Escalade so Diddy wouldn't step on her face no more, bro. All because he was in the spot flirting with a chick, and she went like this. So the abuse was just too much, bro. Diddy's in there because of abuse, bro. Not because of his sexual experiences, bro. He was too violent. He was doing too much, bro. Straight. So anybody want to cap for that, stop. If your daughter was there, you would have probably been looking for Diddy right now. You got to stop. You got to stop.
The acquitted guideline, because it would basically, it's just a circular definition with relevant conduct. And I think that's not what the judge was saying. It would be a smaller subsection of things, much smaller subsection of things than anything involving relevant conduct.
I don't agree, Your Honor. And I think that it's a distinction without a difference, because the concept of relevance, as the district court was using it, as Your Honor seems to be using it, is the same as Rule 401, which is incredibly broad. And as this court has, repeatedly held, it's a very low bar.
And it state lines. That's what he got back with.
Basically includes sweeps in, many things. And
well, no, take this. Defendant is convicted of one bank robbery. At sentencing, the judge considers 10 other bank robberies that were committed on completely different days using, and let's posit, completely different modus operandi. But it's relevant conduct. And so the judge considers all 11 bank robberies when calculating the guidelines. I don't think that one would then say that had there been a trial on bank robbery 1, all of the other 10 bank robberies would have come in as relevant evidence, because under my hypothetical, where there was no common MO, they would not be admissible under 404B. So I don't think if you draw a Venn diagram, you're going to find perfectly coinciding circles for relevant conduct under 1B1.3 and relevance under the rules of evidence to prove up an offense.
Well, even if that's the case, on what we're dealing with here, this evidence of coercion would not have come in to prove the Mann Act. Clearly, it would have violated 404, 403. There are numerous reasons that I think it's pretty indisputable that if all Mr. Combs had been charged on and all he'd been tried on was Mann Act, that we wouldn't have,
But what about the idea that if he had, let's say he was only charged with the Mann Act and his defense was along the lines of one of the things the defense raised at trial, which is he never intended for the specified activity to happen after these folks crossed state lines, that it just kind of happened. And one of the ways the government tried to disprove that or tried to prove his intent, was saying, no, he used to talk about this all the time, what he wanted to happen. In fact, there was one time on a plane that within 24 hours before the event happened, he actually showed a woman videos of prior episodes where the activity had happened. And sure enough, within 24 hours, that's what he arranges to happen. Again, that's proof that this is exactly what he intended to happen. It is not mere coincidence. Why would that not be admissible?
That's not what the
I don't like how the Diddy's defense is going at this, bro. They're not going at this right. They're trying to move it like he's innocent or some stupid shit. You can't go at it like this, man. I don't like what they're doing, bro. Because everybody know when Diddy started FO, the train don't stop. Diddy said, you not going to fuck up my night. Oh, you not. When the train going, we not stopping the damn train, homie. Sandals of Jesus. On Jesus sandals. Jesus feet moving right now. What? One day Cassie was damn near OD'd. She OD'd. It was her and Dave, supposedly, allegedly. That's the dude who's suing her now, right? This is why he's suing her too, because of that one of the instances right there where they went to like a swingers club. She said they did trees, they drank liquor, and I think she popped a date grape drug. You know, they was popping self-date, they was self-date graping themselves. So I think she popped like one of them things. She went to the FO. Obviously, they went to the FO, did the FO. Obviously, she was in an active FO. She said she woke up in the shower with the water running on her like she damn near died, son. Diddy and Dave. What's his name? Colin? Whatever the name, white, the black dude with the glasses. They was looking over her like they seen a ghost, Patrick Swayze. They like this. The fuck? Son, she woke up. You would think she need to go get some medical treatment. A woman that damn near passed out, all of that shit, didn't even know where the fuck she was, damn near died fucking around upper room when Jesus come. Bruh. Right after that, choo choo. You gotta get right back on that train, son. She got out that tub with her wet body and got her ass back in the FO. Do you understand that, bro? Crazy. Crazy. So I think the defense need to make some better arguments when they come at it. They're coming at it like some innocent point or like Diddy's the victim here. Stop talking like Diddy's a victim. But he's a victim of the system. Relax. Mentee a black man in there is a victim of that system. But you got to talk with a better, you know what I mean? You got to come better, though. You got to come better, bro. You coming like he's a victim, and that's not going to work. That's why they're giving her so much fucking pushback, bro.
defense to the Mann Act was most of the case was focused on the coercion in the RICO, and to the extent
I thought that was part of the defense, no?
No, it wasn't, Your Honor. That with all the only arguments that were made specifically about the Mann Act by the defense was the argument that based on the testimony of the and the evidence in the case was that the escorts were paid for their time.
Well, right. That's the same argument. They were paid for their time, and everything that happened afterwards was just not something that he was arranging. He was not transporting them for the purpose of what happened afterwards. It was just their time.
I guess I'm getting a little lost. I apologize. But I think the point here is that the principal point here is getting back to Your Honor's earlier questions and my dialogue with Judge Baker is that you have to look at the elements. That's our position. You have to look at the elements. This idea that you have a relevance test is not consistent.
But your argument,
and I just want to highlight. I'm sorry.
Well, no, that's a question.
Sorry.
I'm sorry. Well, finish your point and then I have a question.
I just wanted to highlight, and we've mentioned this in the briefs, but if you look at the history of the guideline, the Department of Justice wanted the commission to use the phrase relates to in the guideline, and the commission rejected that because they thought that was far too broad, and they went instead with the language that's in the guideline.
So the problem that I have with your test of an elements test is that sometimes the problem is we have different elements, right, for the RICO, for the sex trafficking versus the Mann Act. But there's evidence, conduct that can underlie the government's case, right, in all these sets of charges. And the mere fact that you're acquitted doesn't, by the very plain terms of the guidelines, right? It doesn't take it off the table insofar as that conduct is also convicted conduct. And so what we're trying to discern here is where's the line, right, for purposes of sentencing, and And so you just can't rely upon a test of the because it cannot be that just because in all conduct that is underlying the element of acquittal is then taken off the table, right? It can't by itself.
Well, I don't agree with that because I think it's going to depend on the case, right? And there are going to be cases that are maybe closer than this one.
Right.
So you're going to have cases, for example, where there are maybe inconsistent verdicts, things like that. That's not the case here. This was very clear. You know, I sat through this trial for 8 weeks. The government's focus from beginning to end was on the sex trafficking and the RICO. The whole, where the debate was there coercion or was this sex voluntary?
Right,
That was the gist
The
of
Mann
what
Act was an
being
afterthought.
disputed.
It was an afterthought. The Mann Act was just an afterthought, and the government's to prosecute. I mean, it was there, but it was effectively a sideshow. But that's the question, right? Can the government then look to all this? Can the district court look to evidence presumably rejected by the jury and acquitting on these other things for purposes of finding the penalty in the sideshow? And why not? Why shouldn't we just hold the government to what it argued?
We should, absolutely. And I think the whole point of this guideline was to deal with the fact that many people in America, not just Supreme Court justices, not just other judges, but, you know, have really questioned whether it is both constitutional and right and consistent with respecting jury verdicts to allow acquitted conduct to be used to drive a sentence in this way. And I want to highlight that, and we mentioned this in our brief, but I'm not sure we gave it the prominence it should. This sentence was the highest sentence ever imposed for a Mann Act defendant sentenced under the same base offense level and criminal history category.
Well, let me ask you about that.
You should have opened with this.
Would this offense be let's take the violence off the table, right? The allegations of violence that the jury rejected in the acquitted counts. What about would this verdict? Would this sentence be substantively reasonable in your view, given that we also have factual findings of psychological abuse, emotional abuse, and applying these two women with drugs? One of them became an opioid addict as a result of it. Would that, presumably that's still on the table if we take away the violence.
I think that it would be substantively unreasonable under the correctly calculated guideline range because it would be multiples. It would require a variance upward based on the acquitted conduct. And
that's not. But it's the guideline range is just. It's not a per se rule. It's a guideline, and it's a starting point. But then you look at the facts of the case, and we have two statutes that tell us you look at all these factors, and we have one statute that says there's no limitation. And am I correct in understanding that we have this factual finding that we have two women who were plied with drugs to participate in this, and one of them became an opioid addict. And so doesn't that support the reasonableness of this, putting aside the violence?
Well, a couple of points. First of all, you're correct that that's what the district court found. There's the evidence in the trial is much more complicated than that.
But you don't challenge on appeal those factual findings. You're not challenging that factual findings. You're making legal arguments.
But this court has to review the sentence based on the guidelines calculation taken as a starting point. And this is actually where I was going. I don't even think I got to this.
You did it.
Supreme Court in Martinez-Molina and this court in Seabrook and many other cases have held that a guidelines miscalculation is a significant procedural error that requires a remand and resentencing in most cases, even under plain error review. And so, for instance, this court has held that if you accept the guidelines argument, even in part, a significant upward variance would have been required, and a remand is required because the judge would have had to explain that variance. And indeed, this court has held that even where the sentence is within the range of the correct guideline range, a remand is necessary.
But sometimes, go ahead.
Sorry. What do we do with the fact that the district judge here after each guidelines finding, made the statement that he would have imposed the same sentence with or without this increase. It seems to me that if we accept the judge's representation that that guidelines decision, it was not what drove his ultimate sentence, that then moves us into the question of whether he could have used the acquitted conduct for the 3553A calculation. But how do we get over that sort of potential harmless error hump that he did make that statement after each increase was imposed?
So this court has repeatedly held that a major variant that the district court cannot insulate itself from appellate review by saying that he would give the same sentence. The Seabrook is one example. We've cited others in our brief, and the Supreme Court in the Molina Martinez case, and this court and other cases have pointed out, for example, that this isn't like a new trial and a resentencing,
Yeah, but sometimes we have affirmed. I mean, I understand you can point to some cases where we say, you know what, we're not sure the guideline error really was harmless. We don't know. The judge said it wasn't, but we don't have a high level of confidence. The judge was very emphatic here.
well,
and careful. So it doesn't sound very boilerplate. It doesn't sound like anything the district judge did here was boilerplate.
It's also clear that the acquitted conduct drove the sentencing.
And then we would get into the Sixth Amendment issue, right?
No. I'm talking about the guidelines calculation as the starting point. And the other thing that is really important here is that the district court's guidelines calculation exactly mirrored the PSR, and it seemed clear that the district court was really planning to follow the PSR. And indeed, when he imposed the sentence, he initially said he was following the recommendation.
Wait. Are you implying that the district court wasn't thinking for himself and that he was?
No, not at all.
Then what does this argument about tracking the PSR have to do with anything?
It has to do with the fact that the guidelines range was very important in the ultimate sentence.
And you're saying that the district court must have placed the same weight on the guidelines that the PSR did?
No, that's not.
Then what is the implication? I'm trying to understand what your implication is. Because it sounds like you're going to a place where the district court was not thinking for itself or was somehow implicitly adopting parts of the PSR that it didn't or something.
No, Your Honor, that's not what I'm saying.
Then what are you saying?
My point is simply that this court has repeatedly held that significant procedural errors require remand. I mean, two of the cases.
That I understand, but no, I want to go back. What were you talking about with the PSR? Because I don't understand that point.
Okay, what I'm saying is that you don't know what the district judge would have done if he had understood the guideline range to be either 21 to 27, which it would be if you accept all of our guidelines argument, or 30 to 37 if you get rid of the grouping, just for example.
Even though he told us what he would do. I understand the argument. I would understand. I don't think you made it quite this way, but maybe this is what you meant to say, that if we agree with you that all of his guideline enhancements were wrong, he never said, and even if all of my guideline calculations are wrong, I would do the same thing, as opposed to any individual thing. So if we found one guideline error, though, he said to us he would have done the same thing. And you're saying that we don't take that at face value?
That's correct, Your Honor, under the precedents. And
well, some of them we do. I mean, there are some cases where we have reversed and remanded, and there are others where we said, well, the judge told us he would do the same. So it's harmless.
We don't have a case where there would be a significant upward variance like this. We don't have another case the government could possibly cite where the sentence was the highest sentence for any person in this criminal history category and base offense level, even including others who had a coercion enhancement. There's no case remotely like that the government could point to. And indeed, some of these cases involve things like in the Bennett case, and I forget the name of the other one. In a couple of the cases, the judge says the guideline range is X, which is a little bit above the statutory maximum, and then sentences well below the statutory maximum. And this court says it has to go back because the judge thought the guideline range was higher than the maximum. So, in that case, clearly there's been a significant departure from what it could have been, and the judge gives reasons, but the court sends it back. And And that's what the court should do here. That's what's required by those cases.
Okay.
I understand your argument. I mean, I fully understand your arguments about the acquitted conduct for purpose of the coercion and leadership enhancements, right? Those were four points apiece. But when it comes to the victim, the characterization by the district court of Ventura and Jane and the escorts as victims, that's not really, as you framed it, it's not really an acquitted conduct argument. You're just arguing with or disputing the district court's characterization of these people as victims. So that doesn't really fall into the acquitted conduct bucket for purposes of deciding this case.
I mean, I think there's two issues that we're raising there.
I know the law professors agree with us on that because they don't join you on that. The law professors who filed you, by the way, a very helpful brief. I'd like to thank them for that. But that very helpful brief they stopped when they got past coercion and leadership.
That's fair, Your Honor. I think our principal argument on that, we are arguing that the acquittals show that the jury didn't believe the two women were victims, but our principal argument there is that the term victim should be interpreted according to its plain meaning, which is someone harmed or injured by the offense, and that the application note is inconsistent with that plain meaning. So even under Stinson, the grouping calculation was incorrect, and we're also preserving for further review a challenge to whether Stinson is good law.
Right, but so for acquitted conduct purposes and looking at harmless error and how this might have played out if there was a mistake under the guidelines, we're only looking at we're talking about
it's almost double.
Right. Well, it takes us from, if we did 8, it would take us from, that would go from, we went from 50, would take us to 20. It's only, we're talking about 8 points, right? We're going from level 14 to 20.
The range would be 30 to 37 under that scenario, as opposed to 70 to 87, which was the starting point.
Can I ask you about the definition that the commission has given us of acquitted conduct? One of the things you pointed to contest the government's view is that there was a government proposal that acquitted conduct be defined using the word relating to or something like that. Related to. And the government has also pointed to a proposal that was before the Sentencing Commission that would use the word elements. And neither one of those was adopted. And instead they took this other definition that, as far as I can tell, they decided they didn't need to define further and said something along the lines of, don't worry, it won't come up that often and it's going to be really easy. District judges are going to be able to figure this out. Why should we worry about line drawing? And as I recall, there was a letter from the Judicial Conference Committee on Criminal Law warning them that this was a very ambiguous guideline, and that they very much should provide more clarity. And they didn't. They didn't take an elements test, which I think would have been very clear. And they didn't take the government's relating to. And they gave us one that says, don't worry, district judges are going to figure this out. And I don't know, maybe the district could figure it out. I'm having trouble as an appellate judge figuring it out. What are we to make of it if we decide that it is ambiguous? Does the rule of lenity kick in to guidelines issues? Are there other interpretive principles?
There are two interpretive principles. So one would be the rule of lenity, and the other would be the related, but maybe more important, constitutional avoidance principle. And even to the extent, I understand the panel's position regarding, or Your Honor's position regarding the binding nature of those precedents we talked about earlier. But putting that aside, I think it's clear that at a minimum, there are serious constitutional concerns with using acquitted conduct. And so I think, if the court finds that the guideline is ambiguous, it should be interpreted, the exception should be interpreted narrowly in favor of the defendant.
And this is, I swear, my last question. I don't know about my colleagues. Are you aware of any other appellate courts that either have decided this issue or are facing it right now? Is this bubbling through the circuits in other ways where we are soon perhaps to benefit from the views of our sister circuits?
I am not aware of any other appellate decisions interpreting.
That's not good. These are the things you got to know. You're supposed to know these other cases where you could cite that this is happening right now. Like, come on, bro. Stop. Appellate court is on smoke right now. Straight. They on smoke. Pushback. This is called pushback, bro. Pushback.
Interpreting the guideline, there are some decisions, relating to the Watts issue, but.
Sure, but you're not aware of anything currently bubbling?
My colleague advises me that there's a case pending in the First Circuit on this.
Do you happen? Well, that's fine. Well, if it comes out, that's fine. If it comes out, we'll find it, but that's helpful.
Okay.
Unless there are any further questions, we have kept you up considerably past the 10 minutes. So, but don't go away because we're going to see you again in rebuttal.
I'm sure I'll have more to say.
I hope you have a bottle of water there. We will now hear from the government.
Good morning. It might be afternoon at this point, but may it please the court, my name is Christy Slavic, and I represent the United States on this appeal as I did in the district court proceedings below. Judge Subramanian correctly applied the new acquitted conduct guideline in this case. And moreover, in determining the appropriate sentence under Section 3553A, Judge Subramanian properly considered the aggravated manner in which the defendant carried out his Mann Act offenses, which is, of course, consistent.
You say aggravated manner. Let's talk about that. Why shouldn't we hold you to the way you prosecuted the case? You went to the jury and you said, this man did all these terrible things for purposes of the RICO conspiracy, for purposes of sex trafficking, and they acquitted him. And then on the Mann Act, it was just a sideshow, and you put him. I don't think there was any evidence or any live witness testimony. Just look at this. You said, look at these charts, and now you want us to rely on all this acquitted conduct that was presented to the jury that was presumably rejected for purposes of or to allow a district court for purposes of the guidelines calculation. So why should we hold you to what you present?
That is good, son. The appeals, I thought they were just swinging one side of the fence. They busting their gun now, bro. This is a fact, bro. This is a fact what they're doing now. They said all kind of things that they alleged. Lace baby oils. It was mad stuff, bro. All of those things were thrown away. Only two things stuck, right? Why should it? Let's see what she got to say.
To the jury.
Your Honor, I have several responses, but
Please.
First is that much of the conduct that the district court focused on in imposing the sentence was not acquitted conduct at all. In fact, it was admitted conduct. The extreme physical violence that took place in the context.
You know what they're going to use against Diddy? In the very, very beginning, when the trial first started, in the open arguments, whatever, the defense came out to say that this is not a domestic violence case. And if this was a domestic violence case, then we would plead guilty then, basically. So why are we here? So that same stance that the defense took to say that, yo, if it was domestic violence and all of that, we would just raise up our hands like this. They used that. The judge also used that against Diddy in sentencing to say, look, man, you said you're guilty. Y'all admitted that y'all were guilty of these violences, though, as well. These aggravated factors.
Of these freak offs.
That's not, I get all that. I understand that. That's not my question to you. My question to you is, why shouldn't we hold you? It's not what the government, what the district court relied upon. I'm asking why we shouldn't hold you in terms or require a district court to hold the government to what it presented to the jury for purposes of, for deciding the scope of acquitted conduct, to look at what you actually presented to the jury for purposes of those charges, and then asking, did it overlap with the acquitted charges? And I don't think there's any overlap here.
Sure. So just backing up a moment to talk about how the case was presented. Counts 2 and 4 were the sex trafficking counts, and those, of course, were acquitted counts. Counts 3 and 5 were the Mann Act counts. all counts were charged as courses of conduct as opposed to specific instances. And for counts 2 and 4 that related to Cassie, that course of conduct related to the freak-offs that took place between 2009 and 2018, I believe. With respect to counts 4 and 5 that related to the hotel nights with Jane, that course of conduct was from 2021 through 2024. So the evidence of the hotel nights and the freak-offs related both to the sex trafficking and to the Mann Act charges. And that's how it was presented to the jury. It was never presented as this evidence relates to sex trafficking and this evidence relates to the Mann Act. There was never a dividing line.
But when you get to summation, there is, right? So you say,
bullshit.
Let's start with count 3.
That was bullshit. Slavic, you try to get away with one right there. Slow down. Let's see what the hell's going on. Everybody slap the like button. You know, Uda not a beggar. Slap the like button. Thank you.
The defendant is charged in count 3 with interstate transportation for the purpose of prostitution related to freak-offs involving Cassie. That's how you describe count 3. I think that's right. And then you go on to talk about all of the evidence about escorts traveling. And it doesn't talk in your discussion of count 3. And similarly, it's a very, very mirrored for count 5 when you talk about Jane Doe. Doesn't talk about Ms. Ventura or Ms. Doe being coerced or Ms. Ventura or Ms. Doe being transported. It says count 3 is about escorts traveling for the purposes of contact with Cassie. And count 5 is about escorts traveling for the purpose of contact with Jane. As Judge Baker is saying, where else can we divine the government's theory of those 2 counts other than summation, and why shouldn't we hold you to it?
So just to be clear, the government's theory was that the travel involved both Cassie and Jane and escorts. But I think
that what you said in your closing.
I don't have the exact words of the closing, but that was. I think that your other question is, why shouldn't the government be held to what it argues?
Let me just stop you for a second, because the last thing you say on count 3 is, quote, all of the examples that I just went over showed the defendant caused commercial sex workers to travel across state lines for freak-offs. The defendant is guilty of count 3 based on any single one of these instances. Then you say, let's move to count 5. So that's how you started and ended count 3.
So the point was, the government in closing went over several examples. It was not a comprehensive list of all the instances of travel because
no, but the theory was that he caused commercial sex workers to travel. That was the theory on which you asked the jury to convict Mr. Combs on count 3.
Facts.
Sure.
Facts.
Not
Facts. Because Diddy was basically kind of say that all of them was basically like scorts in a way, right? Because they was all in the act together. Even though these people are coming through. Remember the dances, they said it was dancers. They was never referred to as escorts in the court. I'm talking about the government called them that, but the escorts themselves never called themselves escorts. You know what I'm saying? They said it was dancers, entertainment. Cassie and them never called them escorts, called them dancers, called them entertainment, things like that. Diddy was even trying to say that, yo, bro, I was a part of the energy too. So how y'all trying to, when I was in the thing, you know what I'm saying? I get it, but.
Not that he caused Ms. Ventura to travel or that he coerced Ms. Ventura into something. The theory was he caused commercial sex workers to travel. Other than the constitutional challenges, there's no sufficiency of the evidence challenge to that for good reason. It looks pretty much like he did. But that's the government's theory, right?
That was the government's argument at closing. I think kind of backing up the import of this line of questioning is, shouldn't we hold the government to what it argued in closing? And I don't think that that's right. I think the theory is, if the government made this argument, doesn't that mean that the jury accepted that argument and didn't consider any other possibilities? And I don't think that that's a fair inference.
But what we're trying to do here is to figure out where, draw this line. So the jury acquitted on certain things and then convicted on other things. So what does a jury have to rely upon? Don't you think they're listening very intently to the closing argument? Isn't that going to be very, very important in their consideration?
Of course, Your Honor, of course. But the jury in this case, was properly instructed on each element of the Mann Act and had to find each element of the Mann Act met beyond a reasonable doubt. And I think it's, as a logical matter, I think it's an impossible task to discern the minimum quantum of evidence that would be sufficient to sustain the government's burden. And I think that sort of inquiry also goes against this court's precedent, specifically the Martinez case that says a court only knows what the jury's verdicts were, not what the jury found.
Well, right. No, and that, I don't think anybody's questioning that. But the problem for the government is that there's a new guideline that says, figure it out, that basically says there is such a thing as acquitted conduct. And as Judge Subramanian pointed out, I think quite accurately in sort of speaking with the greatest amount of precision possible, there is no such thing as acquitted conduct. Juries don't acquit people of conduct, they acquit them of charges. They find that certain elements were not proven beyond a reasonable doubt. They don't find that someone's innocent. But now the guidelines,
That's what Judge Subramanian said.
have been amended. So there is a thing called acquitted conduct. We've got to figure it out. So the question is, how do we measure that? So we're not looking at general principles like Martinez saying, did the jury find something? The only place that you're going to find, I think, in our case law where we say an acquittal necessarily implies something is in our collateral estoppel branch of double jeopardy jurisprudence. And I think, I guess one question I would have for you is, why would that not defeat the government's argument, at least with respect to coercion in this case, if, for example, the jury had hung on the sex trafficking count, right? If the jury had hung on, well, no, no, my hypothetical is spinning out of control. I guess what I'm wondering is if there were some hypothetical additional count that the jury had hung on here that required a finding of coercion with respect to one of the two victims, why you would not be collaterally estopped under the double jeopardy clause from retrying the defendant on that count. Let's say there was a conspiracy to commit sex trafficking.
Well, let me just push
Why
back
would that
on,
not be
Let me just push
precluded?
back on this hypothetical that a foundational issue that I have is that the defendant was not acquitted of coercion. He was acquitted of sex trafficking by force, fraud, and coercion. The jury was never asked, was there coercion?
Right, but we have,
Sorry.
well, under that theory, there is no such thing as acquitted conduct. So you're kind of fighting the very principle of the guideline. You're saying that because there were three alternate elements, I think, fraud, force, or coercion, that because there are three alternate elements, there is no acquitted conduct. But you have to accept the premise because the guidelines have been amended. There is such a thing as acquitted conduct. So why don't you actually, let me frame it this way. Under your view, with respect to count two, what is the acquitted conduct?
So the commission thought very long and hard about this issue, clearly, and they declined to set any bright line rules.
Yeah, but now here we are.
Exactly.
So what's the government's view of what the acquitted conduct is underlying count two?
So I think Judge Subramanian's test, which is
No. That's. I think Judge Subramanian's test is what's overlapping conduct.
as a first step to Judge Subramanian's test, he described acquitted conduct as conduct that underlies the.
Yeah. So you tell me what
that,
conduct underlies count two.
What specific conduct? Yeah. Well, I think a good example of conduct that could be considered acquitted conduct that the judge did not consider in applying the exception was the intercontinental video. That, of course, was evidence presented at trial that showed the defendant assaulting Cassandra Ventura during the course of.
So that's acquitted conduct in your view?
I think that that's a fair characterization.
So that's a use of force, but the other conduct that illustrates use of coercion is not acquitted conduct.
The reason that that's acquitted conduct, in my view, is because that does not tend to prove the elements of the Mann Act.
No.
That's the second question.
No. There's two things here. You can have acquitted conduct and you can have offense conduct under the guidelines, and they can overlap. And that's why the guidelines say where they overlap, you can consider them. So the government sort of doesn't lose by saying something's acquitted conduct here, because then the district judge, if it's overlapping, can still consider it.
Right.
So let me ask it this way. There is evidence on the flight back from Cannes, that Mr. Combs sits next to one of the victims and shows these videos of the events that have happened in the past, and the government's argument to the jury is that's coercive, right? That this was an implicit threat, right? His discussion of releasing these videos was implicitly, if you do not continue to engage in this conduct, I will release this publicly, and that will destroy your reputation, right?
That's right.
So it seems to me that that's clearly acquitted conduct. I thought the government's argument is that it is also offense conduct. And therefore, because it's overlapping, the judge was allowed to consider it. So I want to ask you about just the first part of my question.
Okay.
In your view, did what Mr. Combs did on the plane back from Cannes also constitute acquitted conduct?
So I think the answer is maybe. I think it depends on the definition of acquitted conduct.
Okay.
Maybe? We using maybes now?
Oh no, you can't be serious. That is some bullshit right there.
You should have heard these women. There's five of them. Johnson, Slavic, and the rest of them. She's talking about maybes right now. They were so confident, so definite in the court, bruh. Boy, I don't know what's going on, man.
Government's definition, is it acquitted conduct?
I think the judge properly.
No, under the government's view. Forget it. Let's pretend it's before sentencing happened. Under the government's view, is that acquitted conduct?
I don't think that because the defendant was not acquitted of coercion, I don't think it's
was he
necessarily.
not?
Because
Unless you're saying he wasn't acquitted of anything. Because if there was fraud, if there was force, there was fraud or coercion, he's guilty, right?
what I'm saying is, no, I don't think that that's right. It's not just if there was force, fraud, or coercion, he's guilty. He had to know or recklessly
Right. There are
disregard.
multiple of elements. But I think what your argument would lead to is that there's no such thing as acquitted conduct, because there's always multiple elements. One can't, from a jury's acquittal, ever know which of the elements they found unsatisfied. Ipso facto, there's never a category, there's never a bucket that's filled with something called acquitted conduct. Tell me why I'm wrong about that. In what world is there a bucket that's full of acquitted conduct in your position?
Your Honor, I think this case is I think presents a lot of gray lines, and I think that the cases that come up in some of the dissents that the panel has already mentioned, related to drug cases, for instance, where there's a conviction on a conspiracy count and an acquittal on a distribution count, or vice versa. And there's a special interrogatory where the jury finds specifically some amount of drugs. Like, I think that is very easily described as acquitted conduct.
Absent a special interrogatory, when does your test yield anything that constitutes acquitted conduct?
Your Honor, I think that in those sort of more straightforward cases where facts were presented directly to the jury and rejected by the jury, I think.
When does that ever happen except with a special interrogatory?
I think that can happen in, for instance, a 2-count drug distribution case. In one count, there's a conviction. In one count, there's an acquittal. I think the acquitted weight of the drugs would be.
Each of those counts, let's assume it's a distribution count. Each of those counts has multiple elements, right? Knowing what the drug was, distributing it purposely, right? I purposely handed it to you. That's how I knowingly distributed it. But also knowing that it was heroin, right? Because the defense might have been, I thought it was fake drugs. I thought I was cheating, right? Each of those has multiple elements. So you're always going to be in a position, if you're the government, taking the position I think you're taking, of saying, well, I don't know whether the jury found that he didn't know it was heroin, or I didn't know that he thought that he was purposely distributing it, or whatever it might be. So I don't understand your argument.
I think going back to the guideline itself, which does create a thing called acquitted conduct and convicted conduct, the commission deliberately did not define either term, leaving us in this position.
But it clearly must have some content.
Exactly. I think
and it
that's
can't
right.
be what we have always said under the Sixth Amendment is true, that there is no finding implicit in a verdict of acquittal. So that's off the table as to what the commission was trying to say.
That's right, Your Honor. And what the commission did say is that the court is in the best position to determine what is acquitted conduct and what is convicted conduct.
According to some rule of decision, not in terms of arbitrarily deciding A in one case and B in another. So we are tasked, as the district court was, with coming up with an articulable rule.
Sure.
So here we are.
And can I ask you please to articulate what's the principle? We have to write an opinion. It's the same question I posed to your friend. We have to write this opinion. What is the principle that distinguishes acquitted from convicted conduct?
So acquitted conduct, one thing that I think is supported by the commentary is that conduct that underlies an acquitted charge can be considered acquitted conduct. That's like the first step. The second step, of course, is whether that conduct can nevertheless be considered as relevant conduct. But that's that first step, what is acquitted conduct? What Judge Subramanian did is said, acquitted conduct is conduct that underlies an acquitted count, right? And under that definition, in this case, there was a lot of overlapping conduct. And so he had to determine what
So how do we know whether there's overlapping conduct? Where do we look to determine that?
I think that's where the judge's discretion, the judge who's overseeing the trial.
But this is, we're trying to find out what the purpose of the guideline is, to make sure that the jury's acquittal isn't negated. So we're trying to understand what this is difficult, right? We're trying to understand what the jury did. And we have a conviction and we have an acquittal, right? So we're trying to understand what the jury did.
So I think that the appropriate test here is the test that Judge Subramanian articulated, which is to assess whether the conduct can still be considered as relevant conduct for the purposes of the guidelines. He looked to whether that conduct tended to establish an element of the convicted count. And in this case, those two narrow instances.
Well, let me ask you that. Why does the coercion tend to prove, say, with the conflict? Why does the coercive nature or the coercion, strictly speaking, tend to establish the Mann Act, as opposed to, let's take coercion out of the equation, the fact, you can still look at the underlying raw facts, Mr. Combs coming back in the plane, sitting next to Ms. Ventura, showing the videos and all that, that evidence could still be considered, say, fairly to ascertain what Mr. Combs's intent would be for the events that would follow. And yet it could not, say, under the defense's view, be considered for purposes of establishing coercion, because coercion was an element of one of the acquitted offenses.
So I think to answer your first question, which is how does the travel in Cannes and the situation on the airplane, how does that establish the Mann Act? I think it's for the reasons that Judge, you articulated in your colloquy.
Right. And I'm saying, let's grant you that. Let's hypothesize that the events on the airplane are admissible and were properly considered by the judge to figure out, did Mr. Combs really intend what was all going to happen was going to happen? Let's just posit that. But isn't there a world in which the guidelines say, yeah, you know what, that's fine. Consider it for purposes of the Mann Act elements. But you can't draw the further conclusion that that was coercive in nature.
Well, the guidelines.
Because that's what the jury said did not happen, or did not find happened, and therefore it's acquitted conduct.
So I think because this acquitted conduct tends to prove an element of the Mann Act.
But how does the coercive nature of it, the inference that it was coercive, because I think that's really a distinct fact, right?
That inference is coercion is defined in the guideline. The fraud and coercion guideline, or excuse me, enhancement is set out in the guideline. And the definition under that, coercion under that enhancement.
Let's assume it is coercive conduct. I think what Judge Nardini's asking, and I have the same question, is how does the fact of its coerciveness tend to establish some, in whole or in part, an element of the Mann Act offense?
I think it relates to the temporal proximity between the coercion the
was
threats, I'll
acquitted.
call it, the threats, the transport, and the demand for a freak off.
So let's say the conversation instead was, instead of it being coercive on the plane, was when we get back, my plan is to fly some escorts in and you're going to have sex with them and I'm going to pay them for that.
Sure.
That
I think that would establish the intent.
Exactly. So why is the additional aspect of that conversation, that encounter on the plane that's described, that the coercive aspect of that, why is that add anything to establish in whole or in part the Mann Act offense?
Because I think it's what he's asking for. It's the threats are not followed by a request to go to dinner, a request to, ask Cassie to do the dishes. Those threats are followed by a demand for a freak off. So the coercive nature of the threats are directly relevant to the intent to have the freak off, which then later happens.
Well, okay. Except you've agreed that it didn't need to be coercive in order to support that aspect. The
No,
intent
not
aspect of the
necessarily.
Mann
It
Act.
just so happened in these two specific instances, the threats did amount to coercion under the enhancement. And I think that was, I think Judge Subramanian.
Can I ask you a hypothetical? And I don't know, it doesn't map onto this case, but I'm trying to make sense of the acquitted conduct guideline. We have a defendant who's charged with murder. He points a gun at the victim's head. He pulls the trigger at point blank range, kills the victim. He's charged with first and second degree murder. The jury acquits of first degree, which would have required a finding of premeditation, but it convicts of second degree murder. Let's say it was, some sort of heat of passion or something he just did on the moment. Comes to sentencing. Is the premeditation, which is purely mens rea, in your view, acquitted conduct or not? And if so, is the judge, in my hypothetical, allowed to make a finding of premeditation by a preponderance and sentence the defendant accordingly under the guidelines?
So the premeditation, I think.
Because what I'm trying to do is draw a distinction between the actions, the physical actions. And I'm going to analogize that to Mr. Combs coming back in the plane, sitting next to Ms. Ventura, showing the video, saying the words he said. Those are sort of raw facts. Mm-hmm. Clearly, they underlie, in my hypothetical, the underlying facts of the man reaching over with a gun, pulling the trigger, and killing a victim are raw facts. Clearly, in my hypothetical, they underlie the second degree murder conviction.
Sure.
But the jury has acquitted on first degree murder, meaning they have not found premeditation beyond a reasonable doubt. It seems to me that if we pursue the government's theory here, which is you can consider the facts surrounding the walking back in the plane, the showing the videos and all that, and then the judge can draw whatever inferences the judge thinks appropriate because the facts were properly before the jury on account of conviction, then the judge, in my hypothetical, would be able to find premeditation beyond by preponderance and sentence accordingly under the guidelines amendment. Is that your view?
I think that's right. I think that's right, Judge. Assuming I'm tracking your hypothetical.
And you don't think that is what the commission was trying to avoid?
Yo, Slavic is getting chewed up right now, bro. Slavic's getting chewed up. I don't know if Johnson spoke already. I think Johnson, AU would say Johnson. I think she was better. But Slavic is getting chewed, man. She's getting chewed up.
No, I think the commission understood that there's overlapping conduct, right? Especially in trials of this nature, where these different counts rely on the same factual instances to prove the different counts.
I guess just from a gut instinct, it seems like my hypothetical would be the prototypical example of what the guidelines as amended were trying to avoid. So it seems hard then, if that is the government's view of how it would map out in my murder hypothetical, it's hard to accept how plausible the government's reading of the guideline is more
Your
generally.
Honor, I think hypotheticals are, I find, very difficult in this context. The commission understood that these situations are incredibly fact intensive, and that's in large part because they only come up after a trial. And trials are all different, right? And evidence comes in different ways and weaves together differently. This is a very fact-intensive inquiry. I think what Judge Subramanian did here is he looked at the entire record, all 8 weeks. And imagine that being like a pizza, right? He's thinking about the entire trial as a pizza, all the facts, all the evidence adduced during that 8 weeks. But in considering the guidelines, he's not considering that whole pizza pie. He's considering a slice. And what's in that slice, it's what tends to prove the Mann Act. And that's why when he looks at the two specific incidents of coercion, those incidents are specifically tied to transportation. They're tied to the Mann Act.
And I guess that's where I'm suggesting that I don't know how to follow the pizza metaphor, so I won't try.
Didn't know where he was going with that shit.
That it's a little bit more analogous in my murder hypothetical, that the judge in my hypothetical can consider the physical actions of people, pointing the gun, shooting, the bullet hitting, the victim dying, but would not be able to consider the additional inference of premeditation. So you can still be considering the slice if the slice is considered the evidence that was put before the jury. But I'm suggesting, or I'm positing the possibility that the guideline might limit the inferences that can be drawn to the extent those inferences are part of acquitted conduct, and not also inferences that would themselves constitute an element of the offense.
I think that's right. Again, it's I find it very difficult to think about these hypotheticals in the abstract. But I think here that slice of conduct that the judge considered, those two very narrow instances of transportation, I think undoubtedly tend to prove the Mann Act and also meet the requirements of the enhancement under the guidelines.
Can I ask you, I don't know, if I can change the subject a little bit? We've talked about any number of issues today. Can I ask you specifically about the leadership enhancement? One of the very specific questions we were talking about with your colleague on the other side was whether, as the government submits, there are at an irreducible minimum 5 criminally responsible participants in the Mann Act. And the government, as I understood your brief, said, well, there's Mr. Combs, number one. There are the 2 victims.
That's right.
The
Cassie and Jane. Yes.
Cassie and Jane. So we're up to 3. And the government posited that the 2 escorts who were transported across state lines.
No, that's
not
slightly
what you
inaccurate.
argued?
Yeah, it's.
So why don't you clarify?
Of course.
Of course, because you damn near gave everybody a deal that was supposed to be down with Diddy. So how the hell was you ever looking out for the victims if there are victims in this case? Let's say Diddy go to jail and everybody's outside still. Cassie go to a party and she see Rock and all other people, KK and all these other people. So this further traumatized the victim. You're not putting away the people that helped them commit the crimes that you're saying facilitated these crimes. The people who cleaned the hotel rooms, the people that set up the hotel rooms, the people that went to go get the women back and bring them back to FOs when they didn't want to be in FOs, supposedly, allegedly, right? What happened to those people? It's a one-man RICO. Come on, bro. And you saying that they are 2 of them and the escorts? That's crazy. Let's see what she clear it up and say. That's wild.
The 5 criminally liable participants, besides Mr. Combs.
Yeah.
5 liable, and he's the leader. This is the RICO, they're saying, right? He's the leader, leading role.
Are, as you said, Jane and Cassie, the 2
Right.
victims. And then 2 of the owners of an escort service.
Oh, the owners of the
They
escort
weren't escorts
service.
themselves, but they were owners of the service.
I'm sorry,
Who facilitated the transport of escorts who worked for that service.
Oh,
And
I see.
then-
And so your argument is that because they were involved in the transportation, and obviously in your view, the evidence showed that this whole thing was clearly designed for prostitution,
That's right.
you're up to 5.
That's right.
If we were to agree with you on that point, does that make the whole question of acquitted conduct with respect to the leadership enhancement go away?
Yes, Your Honor. And I believe it could go away in another independent way, which is that the conduct was otherwise extensive, which is another prong of the leadership enhancement. And I don't think that the defendant even challenges that in his reply. So the leadership enhancement is met in both of those ways. With respect to...
Were those, remind me, and I should know this, and I don't recall, did the government present arguments that the escorts and their employers were members of the alleged racketeering enterprise?
No, Your
or
Honor.
conspiracy?
The only individual that the government identified as a criminally responsible participant for the purposes of the leadership enhancement was Christina Coram, who was an employee of Mr. Combs and who was alleged.
My question was about in terms of when you argued the RICO conspiracy count.
Yes.
To the jury. Did you argue that the escorts or their employers were members of the RICO conspiracy?
No,
so
they
I
didn't.
take it your argument would be that to the extent the district judge could permissibly consider the escorts and their employers, there would have been no overlap at all with acquitted conduct. That would be your argument.
Exactly, Your Honor.
And then can you remind us who the judge said, I know I have this here, who the judge said were participants?
Who were criminally liable participants?
For the purposes of the increase, right?
Yes.
It's
James and Collins?
Ventura,
Jane, Combs, Coram, who was the only employee.
And then James and Bridget Collins.
Bridget Kreshover Collins, yes.
Those are the two
Those are the two
employers. So if
escort
we
employers.
knock out, if we were to say to drop out Coram,
That's right. You still have
in
5
your view, you're still
participants.
left with 5.
That's right.
And that's, okay.
And that meets the enhancement. That's
And
right.
then he also said the services of numerous outsiders that were peculiar and necessary to defense.
That's right. And that is to
But
say.
some of whom he included as, among that number, his assistants.
That's right. But the assistants were not alleged to have been part of the racketeering enterprise. So that is, like I said, that's another way to support the application of the leadership enhancement in that case without even touching.
I was the assistant to everybody, not a part of the enterprise. They trying to give them deals. The hell's going on, bro? These people always down with the down. What? Come on, bro.
Acquitted conduct or potential acquitted conduct. You know, with respect to the 3553A factors, you touched on this briefly with my colleague, but as Judge, you pointed out, the case law is binding that under the 3553A factors, sentencing courts can consider acquitted conduct. But I just point out that what the judge did here, what really drove.
I'm going to break this video down into 2. I'm going to break it down into 2 parts. You know what I'm saying? 2 4-hour streams. I'm not on it. About 2 hours so you could come back and watch this. I'm going to set up another one. I'll do another live. Go get my kid real quick. Make sure they're good. But yeah, I'm going to do another one and break it down. I may even drop the link so that we can all talk about this shit, man, and start, you know what I mean, ping-ponging some thoughts on this whole situation. You ain't got to be a master in law or none of this shit. We can listen. We can figure shit out. If you need to use your chat GBTs, use your chat GBTs. You know what I'm saying? And we could just get to the conversation. I don't think Slavic is doing a real good job right here. I think she's actually getting chewed up by the appellate court. They're asking some really, really good questions. She's doing a little thing, though. She's trying. I think Johnson, AUSA Johnson, is way, way better than her. Slavic is really good, though. She was eating in court. I ain't gonna hold you. She was doing a thing in court. But I don't know if she's doing such a good job here. You know what I mean? I salute to everybody that passed through, though, that rock with us, Tina, everybody that came through out there. Shadow, salute to Shadow for sending the super chats and all of that. Salute to that. You know, I don't be asking for too much. So salute to that. Jalen, everybody that's in the chat with us. If you're not subscribed, make sure you subscribe now. Make sure you hit the notification bells on all. And we're going to get back into a breakdown of this whole situation and see where this is going. Because right now, at first, it was looking like, damn, Diddy is looking shaky grounds, homie. It was looking like shaky grounds for Diddy.
Shit right there.
But right now, how Slavic is getting, Mike Tyson punch out. Yeah, it's looking like Diddy got a little shot. He got a little shot in the dark right here, bro. I don't know. So I do want to see what is going to transpire in this whole thing still. So salute to everybody. Make sure that you tap in the notification bells. Make sure that you're notified. And I will be back in a few minutes, and we could just continue on this and see what the hell's going on. Ooda, ooda, ooda. You already know I'm on.
All my niggas from the Ooda. All my niggas turn shooters. Ooda, Ooda. All my ops turn racks. All my niggas turn shooters. Ooda, Ooda. All my ops turn racks. All my niggas from the Ooda. All my niggas turn shooters. Ooda, Ooda. All my ops turn racks. All my niggas turn shooters. Shooters on the road. On the internet, you ain't been a threat. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the Ooda. Welcome to the Ooda. All my niggas from the Ooda. All my niggas turn shooters. Ooda, Ooda. All my ops turn racks. All my niggas turn shooters. Shooters on the road. On the internet, you ain't been a threat. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the Ooda. Welcome to the Ooda. All of my niggas insane. They tryna catch a mistake. Young niggas putting in pain. It in the game, all for the game. Niggas ain't playing for nothing. Went in school, laying it bang. My little nigga kill my little nigga. Full-time job not to kill niggas. Jump off the porch of the field, nigga. You was in the house, I'm a field nigga. No fuck boys around real niggas. Been a drug dealer since a little nigga, huh? Sick of the kilo, they'll kill a nigga. Fuck how you feel, nigga. To get some kilos, I'll kill a nigga too. Throw that rock like I'm Montana. Good head, raise my antenna. G49, not San Fran. Beat the box with my bandana. Then I dip set like I'm Santana. I'm in UK like that Montana. She bring me money, you press her. You got a jug of finesse her. I give a dick that'll change your life. You leave her change on the dresser. Shorty, a wetty, a wetty. That pussy ready, get ready. Don't wanna get ahead of myself, but